I recognise the honourable member, Dennis O'Rourke.
Thank you, Mr Speaker. New Zealand First supports this inquiries bill, and we're glad to see that the century-old existing legislation is being updated. We think it's a bit of a shame that it's taken so long to do this, and when you consider the circumstances around Pike River, the CTV3 building, and the Fonterra debacle, you can see why updated legislation is so needed at the present time. But overall, the bill's a good one and ought to improve the ways in which public and government inquiries are established, operated and report. But the bill isn't perfect, and I've previously pointed to some areas of concern for New Zealand First. I accept, however, that these concerns are not major issues. Concerning reporting, clause 12.2 states that the final report of an inquiry must set out A, the findings of the inquiry, and B, any recommendations of the inquiry. I think it should also provide for the addition of the reasons for the findings and the recommendations, and I accept that while that's probably implicit, it would be better if that was stated specifically in the section as well. Concerning clause 13, I note that 13.1 provides for an inquiry to have the power to request the appointment of counsel to assist it in its proceedings, but in doing so must have regard to effectiveness, efficiency and fairness and other issues such as the subject matter of the inquiry and the most appropriate procedures. That sort of flexibility is very good. This provision will also allow for legal assistance to inquiries, but it must be justified in terms of effectiveness and efficiency. In practice, of course, there will need to be guidance on whether counsel to assist is always necessary, and if so, for what purposes. And I note with satisfaction that the Crown Law Office is to develop administrative guidelines on the role and the appointment of counsel. That would be necessary to enable the general provisos in the section to work in practice. In both public and ministerial inquiries, people can be summoned and can be required to give evidence or to provide information. And we think that is very necessary if we are to get to the bottom of some of the important issues raised by these inquiries. But I'm glad to see that the inquiry is required to comply with the principles of natural justice, especially if an inquiry proposes to make a finding that is adverse to any individual. If it does do that, it must make the person aware and give the person the opportunity to respond to the matters that the inquiry intends to raise about that person. The power to impose restrictions on access to inquiry information in section 15 is another important provision in this piece of legislation. An inquiry may forbid publication of any evidence or submissions or any report or account of the evidence, the name or other particulars concerning witnesses, and so on. It may restrict access to any part or aspect of the inquiry, and all of that is fine. There is a need for restrictions in some circumstances. But before making an order, an inquiry must consider the risk of prejudice to public confidence, because if it is to secrecy, that would certainly be affected. So New Zealand First supported Labour's amendment to make transparency a primary consideration, because we think that's what it should be. Recent inquiries have shown why that is necessary. And after all, the main purpose of inquiries is to inform the public, not just the government. Turning to clause 19 and legal assistance for participants, the legislation states that an inquiry may at any time make a recommendation to the legal aid agency that funding be granted for the purpose of providing legal assistance to one or more specified persons who wish or who are required to appear before the inquiry or who have an interest in the inquiry. And the agency may grant legal assistance. So the concern I have is that the legal aid agency has, by the use of the word may, instead of must, a discretion. Hence, the agency will presumably, apply its income and capital thresholds. It would have been better, we think, for this section to use the word must, so that the parties who are required to appear could, as of right, also have legal aid if they apply for it. We don't think that it is the legal aid agency that should have the discretion. It should be the inquiry itself which does so. So I think the legislation is a little bit defective in that way. However, it's not a major issue. Finally, Mr. Speaker, Section 30 includes offences such as refusing to be sworn or to affirm and give evidence. That is balanced by a provision in Clause 32, which states that a person does not commit an offence if, in C, compliance would be likely to prejudice the maintenance of the law, including the right to a fair trial. While that is an appropriate balance, I have a concern about the term, quote, would be likely to prejudice, unquote, because I think that is an uncertain term. I would have preferred a term such as might in the circumstances prejudice or something like that. I think the bar provided by the words likely to prejudice is a little bit too high. However, again, it's not a major issue. I'm sure the courts, if necessary, will sort that out. Mr. Speaker, while New Zealand First still has these few minor concerns, we do consider the bill to be a good revision of the law on government and public inquiries, and it will therefore have New Zealand First's support.
Call Simon O'Connor.
Mr. Speaker, I am pleased to stand in support of this bill, the Inquiries Bill, in its third reading, acknowledging the broad support across the House for it. I think